Okay.
Section 2. Yeah, so section 2, this is a new bond exemption. And it says in 2D, this is on page 3, the petition for appointment of the PR states that no asset, okay, so go back up to that. Subsection 1, that is the bond requirement before issuing letters, does not apply if D, the petition for appointment of the PR states that no assets of the estate are known to the petitioner and no assets of the estate have come into the possession or knowledge of the PR. So there's a temporal requirement there. And then 3, if the petition for appointment of the PR states that no assets are known and assets of the estate later come into the possession or knowledge, the PR shall, within 30 days after filing the inventory or supplemental inventory, first showing assets of the estate, provide a bond to the clerk of the court that complies with this section unless a bond is otherwise not required.
And then we were gonna change this a little bit to Jennifer's more simple
Yes.
Language, which basically just incorporated all the documents that.
That's right,
Yeah.
there's the account, yeah. So how do folks feel about that? No bond at the outset. If you later discover assets, then within 30 days after filing, and we have the filing requirement later on, but that filing triggers the requirement to come back and get a bond. I guess what this doesn't say, and I don't know that I want to complicate it, letters will issue at the beginning of an estate, assuming that there's no assets. The discovery, I guess the question that this begs but doesn't answer is, and I think it's fine, if you discover assets, you file your inventory, you get your bond, or you get an excuse from the bond for some other reason, your letters are still good. What happens if you don't comply with this section? I mean, we can't say that your letters aren't any good anymore, can we? Because who would know? It's just going to be, you're going to be skating on thin ice, right? What?
Because if the statute requires them, haven't you breached your?
You have, that's what I mean, yeah.
I mean, you get a show cause.
Yeah. Yeah, but there's really no way to say the letters are no longer any good. How would a third party know? And I think that probably raises lots of questions for third parties to say, okay, are these still good? Of course, we do have a 60-day, a lot of places require letters within 60 days. Maybe that's the answer. Yeah, I think I'm fine with just saying, look, you're going to be in violation of your fiduciary duty if you don't do this. I don't think.
Because if it's real property, most folks, I would think, would come in with real property. Right. Yeah.
Okay. Raised and I think we don't need to deal with it. Okay, so let's go on section 3.
On section 2D, can I just ask
Yeah.
a question? It says the petition for the appointment of a PR states that no assets of the estate are known to the petitioner as provided in ORS 111. And, so this is at the petition point.
Right.
And no assets of the estate have come into the possession or knowledge of the personal representative.
Do you think we don't need that last phrase at the beginning?
The only reason I'm concerned about the last phrase is this is at the petition stage, so there is no personal representative, and if it's at the petition stage,
Yeah.
What effect does that have?
That's a good point, because you're right, this is likely going to happen simultaneously with the filing of the petition, or at least almost immediately after.
That's not how it really sounds in the statute, but if that's how it happens.
What do folks think? Because what the order is usually, not simultaneously, but simultaneously you would ask for no bond. No, you would. You'd ask for, in the petition.
Well, it talks about in the petition for appointment.
Yeah, that's right.
Section.
Well, you mean the beginning of D?
Correct.
Well, yeah, but the idea of that is that when the petition was filed, it stated that there were no assets, and since that time, no assets have come into the possession. I mean, if it all happens at the same time, then that's
Yeah, but I guess maybe it doesn't happen always at the same time. I mean, I get your point, Heather. It's likely not gonna be an issue in most cases. I suppose there could be a spread of time. I mean, if you file and you don't have any assets, you don't file a bond. I'm inclined to leave it that way. Section 3, except this is, the notice section, except it's provided in sub 5.
That 3 eliminates the need for the last phrase of D.
What?
Hi, this is Jim Hughley.
Oh, hi, Jim.
Sorry I'm a little bit late, guys.
Thanks. We're in the middle of another LC right now. We'll get the wrongful death here in a few minutes.
I'm just gonna put it on speaker and I'll wait to hear from you. I'm not gonna say a word.
Okay.
Thank
Unless
you.
you care about other probate processes, but,
Yep,
yeah.
Go ahead, thank you.
Okay. Heather?
I just think that it's redundant. The last, D is redundant because 3 says, if the petition says that there's no assets are known, and then later they come into the possession or knowledge, then there's an affirmative duty to file something, so that's just.
Then they contradict each other if you take that last part out, to me.
Well, and maybe what you mean here is that later on, if there's assets discovered, that triggers the duty to address the bond. And so really, what we're talking about right here is, there is no bond, need for the bond initially.
Maybe okay. Well, how about if we do this? I think we leave D the way it is, but maybe in 3, what we're really saying is if letters have been issued without a bond, and maybe we just say that. We don't need to say that whole formula again. Because that's what the whole point is.
Yeah.
So then it separates these two a little bit.
Mm-hmm.
So if the court has issued letters with, under the exemption in 2D.
Yeah.
How about if the court has appointed a personal representative? Because
Well, no, because this is all about,
the issuance of the letters?
yeah, this is all about issuance of letters.
Or, I mean, okay, I get.
Let's do
I get
that.
the concept.
Let's do that. We don't need to go back and restate the, okay, so D remains the same, but then 3 will say, if the court has appointed,
Right.
if the court has issued letters based on the exemption under 2D.
Yeah,
And then assets are discovered. Yeah, because that incorporates it all.
sounds good to me.
Okay, so we will pause on LC 2957, jump to 2960, and that is wrongful death. Jim, welcome back.
I am here.
Okay, good. Who wants to lead off the discussion on this? We do have some new drafting on this. I guess we'll just kind of go through it and then let folks jump in. We have the definitions, or maybe Marissa, do you want to just say anything about the way this is organized? You've got the subheadings here.
Well, I put back in the headings that Shannon requested,
So, just to be clear,
Yep.
are we on LK 8889?
Nope, we're on 2960.
which might have used to have been 8889. Those were just temporary numbers, so
Oh.
I'm trying to move them to the real numbers.
Okay, yeah, that's the one I
Well,
printed.
it's an 889, but I don't have a.
Oh, 889.
I have 2957 formerly 80.
But I don't have a.
Whoa.
Hold on. Marissa, did I get a new copy on this one?
I printed it off.
I must have.
I can send it to you now.
Yes,
Yes.
yes.
So is that pretty much the same as LC 29? That's 8889 and that's not what it is.
Sent out
I'm
everything.
trying to figure out
Yeah.
what changes I may have made.
Yes, folks
Yeah.
on the phone, the operative one is 2960, it's dated 10/29. Sandy sent it out
Yeah,
yesterday.
Marissa, just my read is that was formerly 8886 is what was notated, but
I have my email open from yesterday afternoon, and mine is dated 10/23/18.
No,
8886 is the no asset estate.
yes,
because I didn't know.
It shows up as LC 2957 on the email you sent
Yeah.
yesterday.
No,
That's a different one. Marissa, I didn't know if there was a new, I guess what I didn't
But it
get.
says formally LCP 8886,
But that's the no asset.
yeah. I
We're-
thought that
yeah.
was-
No, we're looking at wrongful death.
Yeah.
Marissa, was there a new wrongful death?
It was 8888.
What you sent it.
Yes, it's 2960, the one that Lane has.
No, it wasn't 8888 is your small estate.
2960, you sent it to us because of the DSL change.
Oh.
Maybe did not send that.
Oh, okay.
That's why I had that one.
Oh.
I don't think I ever got it.
No, because I sent it to you, and then you said I just looked at it.
Yeah, you sent it.
Oh,
you sent
then
it-
I moved it into the new number. So yes, 8889 is the same except for this one change.
Okay, so, everybody, if you've got 8889,
You want me to send me draft?
Yeah.
You know, the draft you sent to me is the one that.
okay, so 8889, if you've got that, you're fine. There will be one change that
There'll be
we'll
one
pick up when we get to it.
Yeah.
The 8889 is sent out to everyone. There's only one change.
It's on Thursday's email at 4:43.
Yes.
All right. We're ready to go.
You're good.
Okay, everyone on the phone is spinning right
Yes.
now. All right, so section 1, definitions. Beneficiary, person for whose benefit an action against a wrongdoer may be brought. Under 30.020, interested person is our standard definition. 3, personal injury claim means a cause of action arising out of injuries to a decedent caused by the wrongful act or omission of another that do not result in the death of the decedent. 4, should that be did not, but 4, wrongful death claim means a cause of action arising out of injuries to a decedent caused by the wrongful act or omission that result in the death of a decedent. Do we really use cause of action still?
Yeah.
We do. Okay. Okay. Any questions, comments on those definitions?
Well, I have a question or comment about Marissa's first comment, which is where did we put this? So are we envisioning, where will this whole series of steps be? Because to me, it seems like these definitions should be with these statutes and not in the probate generally, the probate stuff.
Except if you have definitions that are specific to a certain series, you will put those in the series.
Oh, yeah,
Yeah.
I mean, in this,
Oh, just a second, Jim.
this
Or is it Brooks?
sections 1 to 7, I mean, those
Brooks.
will all be together.
Yeah.
Yeah.
Yeah,
Okay.
yeah. Okay, Brooks.
Just making sure this is intended to plop into chapter 30, right? We're not going to throw this in the probate code and make the PI lawyers go looking for it there. Is that right?
I guess that's an LC question really, more than anything else.
Okay. Yeah.
So let's try and divorce ourselves from that, although if you've got feelings about it, we can express those to Marissa and try and influence LC's decision on that. But for now, let's just focus on the substance, but and keep that in mind when we get to the end, maybe.
Got it.
Comment also says consider incorporating definitions from 111.
Of course, if we're in the probate code, then 111, all the definitions from 111 apply.
Right, exactly, yeah.
Yeah. So that sort of argues for putting it in somewhere in the probate code, yeah. And then maybe we put in an amendment in chapter 30 that just signals to the probate code, so there's a bridge. Okay, so that aside, personal injury claim, the injuries cause death, wrongful death, don't cause death, wrongful death claim, the injuries do cause death. Let's see if that works. Then application, except as specifically provided, chapters 111, 12, 13, 14, 15, 16, 17, 18, and 19, and ORS 30.010 to 100 apply to estates with personal injury claims or wrongful death claims. Let's kind of see how that one fits as we go. Yeah.
I have a note, I don't know if we discussed it, but I thought that somebody had raised a comment about whether the wrongful death claim is a claim of the estate. And so my note was to strike estates with and add at the end of the sentence, so it would read, personal injury claims or wrongful death claims brought or asserted by a personal representative. They have to be brought or asserted by a POR. but that would avoid whatever the argument was about whether they are a claim of the estate.
You could also substitute the word apply to estates with apply to probate proceedings.
Well, I read this, to me, okay, apply to estates with personal injury claims, that's fine, because a personal injury claim will be a claim of an estate, or wrongful death claims. Estates with, I don't necessarily, does it necessarily modify wrongful death claims?
Yeah, I mean, otherwise, what is it talking about? Oh, you
Wrongful
mean,
death
oh,
claims.
you meant, I see what you mean. Well, that's not what I meant by that.
Well, but it actually works. Would you put a comma after?
Well, you could switch them, apply to wrongful death claims or estates with personal injury claims.
Oh, how about that?
Oh,
Would it be or and?
Or you could probate proceedings with personal injury claims.
yeah, I like the switch in the words.
Yeah. It does underscore that a PI claim is an asset of an estate. Okay,
Yeah, sure.
yeah, it should be and, right? Because it applies to both. Yeah, okay. Okay, good. PI claims and wrongful death, PI and wrongful death claims. So this will be the heading, section heading, or the series heading, subheading. Okay, court approval. So this statute now applies to both PI claims and wrongful death. Notwithstanding 114.305, the parties to a PI claim or wrongful death claim may not enter into a settlement agreement without the approval of the probate court, whether or not an action asserting the PI claim or wrongful death claim has been commenced. The personal representative shall petition the probate court for approval of the proposed settlement, and the probate court shall determine the adequacy of the proposed settlement. The petition need not state the amount of the settlement.
How is that gonna work?
So I had a question right there.
Yeah.
How are you gonna know it's adequate?
Yeah.
Yeah. Okay.
The affidavit that the lawyer has states the amount of settlement, and wasn't the reason for that to make us then have the, affidavit be sealed?
We did have that conversation.
Right, so I think that.
Lane
where
and
the
Brooks.
number comes in is where the judge gets that affidavit.
Okay, Brooks? Go ahead.
So you're saying here the petition need not state the amount, but then in section 2E,
Right.
the affidavit supporting it must state the amount.
Yes.
I see this as driven by the fact that many tortfeasing defendants want confidentiality of the amounts that they're paying because they're repeat flyers and kill people all the time.
That was my recollection.
Do we
Not
want
quite.
to address in here anything about the affidavit may be filed under seal if requested or required? Because right now the trial courts vary in whether or not what hoops you have to jump through to make that data filed under seal, and maybe you want to clarify it here.
Okay, let me ask our court people.
I have seen judges go both ways on that.
Brooks is right.
Ceiling, yeah.
Yeah.
It depends on which judge you get. It varies so broadly within that county, it's not even.
Sometimes depends on the facts that are alleged.
I'm sorry, Shannon, what did he say?
Well, there was a House bill, I think that we discussed this, when we asked
Yes.
this last sentence.
Yes.
That there was a House bill that passed about mandatory sealing for affidavits, and so we were
Yep.
just trying to comply with that, so.
I think you're right.
Yeah, they are required to be filed confidentially, which means that they're only accessible by court.
Yeah. And we decided not to disturb that since that was just done in this last legislative session, as I recall.
This is Bonnie. Just, I don't mean to interrupt. So whenever, just let me know, I wanted to make a comment. Sorry, if somebody was talking. Okay. So, and apologize for not being there, by the way. I had ACL surgery and had some complications with it since. So I missed the last meeting, and I really wanted to be there for this one in particular. Okay. So one of the things that I wanted to point out, I agree with Brooks that there is an issue with sometimes you can get better settlements actually if you have a confidentiality clause with the defendant.
Right.
So we would like that opportunity
if possible, to make it easy to file it under seal, because it is complicated and difficult to do that. Another issue that I have with this first section, where it says, may not enter into a settlement agreement without the approval of the probate court. So oftentimes what happens with the settlements, we enter into them, or we do a tentative, like, you know, where we're going to right before trial. And, you know, we're kind of like needing to get into the court to make sure and do things on a fast track basis, because, you know, it's the pressure of the trial that drives the settlement, and to make it as easy as possible to get into court. So I guess I feel like, you know, it's like I want to have a settlement agreement maybe, but then it is subject to approval by the
Yeah, that's a good point, because typically, I think that's the case. You have the agreement and you file the agreement with the court, so you technically, you've entered into it. Maybe, should we just say may not settle?
I think a lot of times when, Bonnie, I don't know if this is what you do, but a lot of our attorneys will just put in the settlement agreement that it's subject to court approval, and that just resolves any.
Maybe so. If you just say it is subject to court approval, then you really haven't entered into it. I guess that's right.
Right. Yeah.
Okay.
Yeah, that's exactly what I do. And I guess it's just such a strong language. It makes me nervous, because it says may not enter into without the approval. So if you're okay, like that, we just say we agree to this, the parties are all in agreement, subject to court approval, then we're not going to run afoul of that section. Okay.
I think that works.
Blaine?
Yeah, Brooks.
Very brief moment of levity. If you make these statutes this clear, it's going to take away a fair bit of my income from PLF repair cases where I have to unwind these things when lawyers have done it without court approval. Just want to make that clear.
Good point, Brooks. We better strike this. Okay.
They're always gonna do that, Brooks.
Oh, no, it's impossible.
It doesn't even matter.
Yeah, that's true. Hey, Brooks, don't worry. I have the feeling we're seeding lots of other opportunities as we go.
Thank you.
Brooke, it's Heather. I'm just wondering, I actually had a question yesterday from a longtime PI lawyer who thinks currently that we are changing the law with this draft. His position is that PI settlements aren't subject to court approval. Even though the UTCR talks about court approval, the UTCR is discretionary. And the language in the statute doesn't currently require PI settlements to be approved.
So as I say at every CLE that I give this speech on, the probate statutes without question authorize the PR to enter into a settlement of a PI case, not a wrongful death case, without court approval. But no probate court that I've ever asked the question of believes that you should be allowed to do that, and you'll get in trouble with them if you do. But if the question is, do the statutes currently allow it, the answer is yes. If the question is, do the UTCRs prohibit it, the answer is yes. How can the UTCR overrule the statute? That's what we're fixing.
Yeah.
I just want to make it clear we are changing the law.
Okay.
And if we're doing.
Absolutely. And I think we're bringing the law into conformance with what pretty much every probate department that's thought these thoughts thinks is correct. And I'm certainly not disagreeing with that.
Well, I'm glad to see the change, but I would just like to see the report from this committee reflect that we recognize.
Okay, want to make a note for Susan? Okay, so then to go back to Bonnie's point, Bonnie, on the confidentiality of the affidavit, there is a statute now that does, and it's separate from this work, but there is a statute now that says those affidavits are confidential documents. So there's really not even a discretion with the court. They are confidential documents.
So my question is, you have a personal injury case, not a wrongful death case. It's settled in secret. The settlement amount is an asset of the estate that's to be distributed and used to pay creditors and heirs or devotees. You have a final accounting. How do you do all that in secret?
Well, yeah, I think I can figure out an answer to that, but go ahead, Brooks.
My experience with that, Rick, and this is a little bit of sort of a veil of well, I don't remember the analogy, whatever. The settlement happens in secret because the tortfeasing defendant doesn't want to be identified as having paid money. Then what I've always told the PRs to do, and maybe this needs to go in the statute, you now need to amend your inventory because you've just come into possession of, you know, an asset you didn't have before. Because I agree with you, Rick, it's subject to your claims and every other creditor. So we get an amended inventory in there.
Or in the
that
account.
trigger a need? Well, I always tell them I think they need to file an amended inventory. You know, in the same way, I mean, I'm the bailout PR on an estate, and I just found out I've got a rental house in Cottage Grove, you know, and I've got to amend my inventory. So I think that has to happen. And then that puts the probate court in the world on notice that this magic pile of money showed up from some source. And of course, creditors don't care about the source. They only care about the money. So that's what I've done. And then, you know, if you've presented your claim, even if the estate's assets were insufficient, now that there's more of them, you have to get paid based upon the larger amount.
Well, I understand why the defendants want this to all be secret. We got a sentence in here saying the petition doesn't need to state the amount of the settlement, yet that information from what you're saying is going to eventually become public anyway.
Right.
And, you know, I do worry about, I've seen this happen, you know, cousin was doing something and uncle was the tortfeasor, and cousin, of course, you know, didn't really want to go after uncle. And so there was no disinterested, you know, neutrality that potentially protects the interests of everybody else in the estate.
Yeah, that's a larger question. You know, I mean, I had one where I was appointed to replace the PR who stole a bunch of money, and my investigation showed it was absolutely uncollectible. So I did not sue the PR, and I explained that in my accounting.
Yeah,
sure.
Well, and we have a Court of Appeals case from the early 90s that says that a PI claim or a wrongful death claim is an asset of the estate for which the personal representative is liable to marshal and.
Yeah, but how do I know?
Yeah, Graves against Tulliners for the wrongful death.
How do you know there's not?
Well,
Yeah.
this is true.
Yeah.
Yeah, and I don't want to subject a PI settlement to a vote of the beneficiaries and creditors, you know, basically by notice and, you know, if it was me, I'd settle this for, you know, that much more. I don't think that, what do you mean? You know, I'm fine with keeping a veil on the settlement if it comes in, and I guess, you know, here's where the creditors might look at it if it's a clear case of liability and damages, and it turns out, you know, settled, what you get is $1,000 in the supplemental inventory. Maybe a creditor would have the right to ask a question about that.
But if you move the court to approve the settlement.
Yes.
The motion has to be served on the interested person.
Right, but they don't know the amount.
So how can you serve the motion without the affidavit? Their interests are being affected.
Well, the affidavit's a confidential document. Already says that.
Yeah, but usually documents in court proceedings aren't confidential from the interested parties in the court.
Well, the parties, but, you know, are they parties? I'm not sure. They're interested persons. Yeah.
Yeah, they have the interest that is subject to the court's authority. I mean, they're the vested real parties in interest, essentially.
Are you denying them due process?
That's my
Oh.
point.
You know, I'm not gonna push this any further. I mean, as long as at least the amount of the settlement is part of the final accounting.
Right.
At least at that point in time, if I have some grave concerns,
Yes, right.
presumably we can file some sort of motion.
Objection to the accounting, sure.
What have
Yeah.
you.
I to me, I think that's fine.
What?
All you could get at that point is potentially surcharge.
Well, yeah, and it may be the case. Yeah.
But you have to remember the court has approved this settlement. The court knows what the number is.
That is true.
Yeah, but how do you have a confidential document filed with court contact parties? In ordinary litigation, the parties have access.
But this isn't ordinary litigation,
And there's a statute.
and there's a statute already.
Well, wait, the statute just says that when it's filed, onto that.
Right.
That means that I can't go down to
Yeah.
the courthouse and ask for that.
It only
If I'm
talks
not-
about the affidavit, not the.
Right, that's right.
If I'm not an interested party, I can't have access to that. I agree with Heather that if you're a party in the case or in the context of a probate, you have to decide whether it's a party.
Yeah.
Interested person.
Right.
That's the job of the probate, is to
This is Bonnie. Can you tell me the statute that makes the declaration confidential?
Do we remember
It doesn't
that?
have a number yet, because it was just.
Oh, that's right. Yeah, it hasn't been codified.
But it is,
Oh,
it was House Bill 4094 or Chapter 59, Oregon Law 2018. Oh, well, and, yeah, what, I'm sorry, what?
Oh, sorry, that's the thing.
Would you like me to send it to Sandy and he can send it?
Yeah, absolutely.
House Bill, what,
I can do that.
4094?
Okay, well, let's figure out the policy question. We can make the statute say whatever we want.
It says an affidavit submitted to a court in support of a petition for approval of settlement of a personal injury claim of an incapacitated person, a minor, or a decedent is confidential. The affidavit is not subject to inspection except pursuant to a court order entered after a showing of good cause.
And by the way, it doesn't mention, since we've created the definition of personal injury claim, which excludes wrongful death.
Right.
It raises an interesting question whether 4094 would still be applicable to a wrongful death.
Mm-hmm.
Because.
and I think Rick is right. Excuse me, I think this is Shannon. I think Rick is right. I don't think it was intended to include wrongful death claims. And my guess with how this bill was received last session is that if we tried to expand it, it probably won't go over too well. So I think that we shouldn't try and extend it to wrongful death. That would be my. I actually talked to Brent Barton about this too, and because he was the one who was backing this bill initially, and he was thinking that it probably isn't the best idea to try to expand this to wrongful death claims as well. Yeah, so we can do, I support whatever the group decides, but I think leaving the, mandatory ceiling for wrongful death, affidavits of reasonableness maybe shouldn't be addressed in this draft. That would be my vote.
Lane Brooks.
Yeah.
If we're going to do a new statute that makes the PI affidavit confidential and doesn't say that for wrongful death, that creates a strong presumption, I think, that the wrongful death one should not ever be confidential, and that is going to gork up a lot of wrongful death settlements.
I agree with that.
Well, there's still, it'd be great if we could do it. And just say it was a very controversial bill last session. And so if we are going to expand it to wrongful death affidavits, then we could be prepared for that.
This is Bonnie. So happy to talk to Brent. Brent's actually in my office, not right now, but he's down the hall. So I can talk to Brent Barton about it a little bit more. And then two, the other thing, so whenever I've had a wrongful death in the past, I go through this other statute in order to seal it. And it's, so there is a method that you can go in and get the court to seal everything for purposes of only that amount of the settlement. But, honestly, this addresses, I think, Rick's concern. I mean, or not concern, maybe comment. If somebody really wanted to figure out how much was there, you just go and you can do the math on the inventory and ultimate statement of attorney fees, and you can figure out how much was paid. So I don't know that it ever really is confidential.
In a PI settlement, you mean?
Yes, yes.
Because the wrongful death never show up on an inventory.
Right, but in the past, when I've had a death and then I've had to, try to get it to where I wanted everything to be confidential, we still have to, like Brooks is saying, I feel like for court, you have to still get approval regardless, even though there isn't a statute. And that's how we've done it, is just filing it under seal. But it's a big pain to do.
Gretchen.
Well, I think two issues here. One is, does this confidentiality affect wrongful death and personal injury? And then the second question is the notice to the interested persons about the information. Now, it does say in this Confidentiality Act that the affidavit is subject to inspection if the court enters an order showing good cause. So if an interested person gets a notice that this settled and they want to know what the amount is, and they can say, I'm an interested person, I need to know how much this is that enough good cause that a court will then allow them to look at the affidavit of your interest?
The difficulty is the court's got a bond on the notice, you know, after it settles and after the court issues orders, you get to know what happened. But your rights, your property rights have already been adjudicated.
Well,
I'm just thinking,
Lane Brooks.
you know, I know this is an ordinary litigation, at least we like to pretend it isn't, but I've had enough probate litigation to know that it is ordinary litigation.
Brooks.
And just to be clear that we're all focusing on the due process problem, the point at which the beneficiary takes the time to ask the judge and get permission to look at the declaration and the affidavit, a probate judge has already said, yes, you may settle on those terms. How in the world does the beneficiary have a right to question that court order by objecting and seeking surcharge at the final? It is a fait accompli at that point. I'm not saying it should be any other way, but I'm saying we ought to be aware that's what we're doing, and that's what we've generally always done. You know, Henry White's estate has said for years, we don't have to tell the beneficiaries we're settling the claim. That's settled law right now.
I'm really not.
Make sure we know it.
I don't understand. I'm really not inclined to go back in and fight the battle of the bill last session, which says it's confidential. I'm inclined to just leave it at that and leave that process, because it sounds to me like it was hard fought, and I don't want to get those warring factions back in front of the committee on PI claims, certainly. So, you know, policy aside, my inclination is that, you know, we're a session too late to answer that question. It's been answered for now. And if somebody thinks they have reason to look at it, I think we could say that, you know, that settlement required, you know, do it like a final account, 20 days. I mean, a minimum 20 days notice. So you can ask the question before the court approves the settlement, if you think you have reason to look at the petition. Do we want to do that? Because if we're requiring, you know, if notice has to go out, if we're going to say notice has to go out of the proposed settlement to the beneficiaries, and borrow language like from the final account that, you know, that the time for objections, you know, 20 days before the court approves, that does give a creditor or beneficiary time to ask the court to let them look at the affidavit. Is that a good middle ground? It doesn't upset the statute that was passed last session. It does slow the process of settlement, but it gives the beneficiaries and creditors a chance to peek if they can show good cause under that other statute before it's a fait accompli.
Bonnie.
Due process argument
But,
by the interested person.
we mean, well, it solves the due process argument, right?
Right.
Yeah, right.
Even if a court said, well, let me, you know.
They at least had their
look at
shot,
that again,
yeah.
The insurance company has already paid out on it because it's already been approved. I mean,
Oh, you mean if we don't do,
if we didn't do the notice?
yeah, right. Yeah, that's the fait accompli, yeah.
And that's the part that I think that there would be a.
Yeah, okay, well, Bonnie, was that you?
Yes, I was just going to comment that I don't think there should be a notice to interested parties. I understand people want to have due process, but in this particular situation, when you have wrongful death claims and you have an attorney who has a duty and you have PR who has a duty, you know, you can't slow the process down, because it's all about trying to get in and get the case resolved and relying on the attorney to, you know, give the best advice possible about whether or not this is, I mean, because there's so much that has to be discussed in order to determine whether or not it's a good settlement, and to have to justify it to beneficiaries is just going to be very burdensome, in my opinion.
Yeah, I understand that argument. It sort of posits the question. There's the efficiency and control of the PR and the PR lawyer in the settlement of this thing versus the interests and concerns of beneficiaries and creditors who might want to have a peek before the horse gets out of the barn and the gate's closed. So committee, what?
So don't you courts require notice? Marion County used to, I don't know if they still.
I don't know, I avoid Marion County like the plague. We're not in court.
Let me get Judge Burton.
I love Judge Burton.
I love Claudia.
Tell her why we're having these problems.
Yeah, okay, committee, we've got a dichotomy, we've got a choice, binary choice between us, before us. Judge, you rule, why don't you rule? You're a
Well,
judge.
I find the due process horse out of barn argument really strong. And even if a court wanted to unwind it, to say for sake of argument, how would you actually do that?
Right.
And let's face it, if.
Releases have been signed and, yeah,
I would argue for 15 days.
15, just to speed things along?
You know, if you're interested in it, get on it and let's get it done. And let's face it, this stuff has been pending for a while. If you're doing it the day before trial, you've been waiting for 3 years, chances are. So I don't see 15 days as something that would be, so especially if your agreement is based on court approval.
Right. Yeah, that's right.
15 days, right now, in our draft of 111, we're modifying the notice time period, and we're making it 15 days instead of 14. Currently, it's 14 or 20.
Right.
So we decided to go 15.
Well, let's be specific in this one, or maybe just, again, okay.
This is Jim Hughley, if I could make a comment.
Yeah.
So, good. First of all, thank you for asking me to participate in this matter. It's very important. I've been doing wrongful death cases for almost 50 years. I'm very familiar with it. I've settled several of them every year. And I've got some very strong feelings about a couple of these issues that are pragmatic. Giving notice to the beneficiaries of the settlement of a wrongful death case and having them have any opportunity at all to jinx it or object to it would be a nightmare. I mean, we work on these cases for sometimes years at a time. We spend a fortune on getting these cases ready to go. And we may end up with a mom and dad who are adverse to the children who are adverse to the decedent, and all of them have their own particular issues. I will give you an example that's very important. Yesterday, I had a father of a decedent walk into my office unannounced at 8:30 in the morning in a case that Sandy and I are working on. This is Martin Blackwell, Sandy, and threatened me because.
Hey, Jim, be aware that I represent Martin.
Oh, you do? Oh, God.
Yep.
Well.
Yeah, I called Tim yesterday.
Yeah, well, there you go. And said, what you're doing is unethical, I've got a right to object, and on and on and on. So having to give an heir notice as to the settlement and having them have a right to object to it will drag the settlement out forever. It will create extraordinary litigation that nobody really wants to be involved with. It would be a huge change in the statute that I think every lawyer that deals in wrongful death cases is going to resist. So there you go. That's just my opinion.
You already have an obligation. It says you have to get the court's approval. So are you filing ex parte, getting the court's approval?
I'm sorry, I couldn't hear you.
So my point is, this is Heather, the statute already requires that you have court approval of a wrongful death settlement. So are you having ex parte with contact with the court when you file a motion to approve the settlement? You don't know the people at this
Wayne
I mean,
Just a second, let's get Jim.
Go ahead.
Go ahead, Jim, go ahead and answer that.
No, we simply file our affidavit of reasonableness with the declaration from the PR as to why we're doing this, with all the necessary exhibits attached. And then the court, in its wisdom, makes a determination as to whether or not the settlement is reasonable or not. And that's the extent of the involvement. The beneficiaries should not have, because all they are is beneficiaries. They only have a right to money out. I'm sorry.
Oh, and creditors, but anyway, go ahead. Yeah, not a wrongful death. Yeah, well.
Not a wrongful death. Creditors aren't involved. So beneficiaries only have a right to apportionment of the money that's left in their portion of the case. So, allowing them to have a right to object to the settlement would be a nightmare. I mean, it would be an impossible case.
Wayne.
Oh, wait, Brooks.
Sorry.
Brooks, are you next?
If you don't mind, I'm agreeing with Jim At this point in the process in a wrongful death case, the court is the stand-in protecting the due process rights of the beneficiaries. If we are going to require court approval, that has to have meaning. This cannot be a rubber stamp, and I'm not suggesting it is. So giving a beneficiary, and let's use the Blackwell example. He's the father of the decedent, and he has very strong feelings. He's not a lawyer. And, you know, he very well could have filed things and objected, et cetera, and bollocksed everything up because, you know, his window of time to object to the settlement has not yet closed. By the way, Jim, I'm not going to be filing that.
No, I understand, Brooke.
But, yeah, but I agree with Jim entirely.
It's instructive as to what happens, regularly.
Oh, yeah. No, you're exactly right. The court protects the due process rights of the beneficiaries unless we're all going to agree that this is mere window dressing, which it's not. Done.
All right. Shannon, was that you?
Yeah, it was. And I just wanted to clarify that, you know, if we start requiring notice for approval of settlement, that is a pretty substantial change of law. As it stands right now, and I know that Brooks just brought this up, Hughes v. White said that, you know, the beneficiaries do not have a property right in the claim itself, and notice is not required to the beneficiaries.
That was a wrongful death case.
It was.
Right?
Correct.
Yeah. The question whether the same is true in a PI case.
So this is Bonnie, and I know I've already said it, and I think, Jim, you said it way more forcefully than I really meant to say, which is exactly the same. I mean, when we look at it from the standpoint of the lawyer who is maybe not in probate, say we didn't have this section, and we are, you know, trying to do the best for our client. There's reasons why we have these ethics rules that really make us go through hoops if we have to then do everything for the benefit of the entire family. You know, you just really need to focus on what is going to be the best for your client. And if the client is the decedent or the PR, then you really, there's just too much emotion and everything that you have to deal with all the time, that notice, even with 15 days, I think it will be a nightmare. And I just very strongly feel that we should not have it.
Then let me just remind the committee that we did invite our PI and wrongful death members of the bar to weigh in on this because we wanted their input. It sounds to me like their input is pretty unanimous. And I also don't want to have this battle in front of the committee.
Basically, you're saying what I was going to say. I'm not real happy about the secrecy component, but I think I keep looking at the practicalities. My fear is that if we go forward, they're going to appear, and then the whole thing is going to be dead. And this is a case of where, am I going to be better off getting at least something? And if we want to make an issue out of the due process, then, you know, we can get at the appropriate time.
Well, and I think when we talked about this before, we talked about this issue, and that was why we created this list.
Yes, that's right. That's right. Yep.
Because the judge is supposed to be doing the protecting of the right. Yep. So I think otherwise, you know, we're gonna have a battle.
Okay. All right.
So we're gonna have to somewhere affirmatively state that parties can have ex parte contact with the court. Yeah, that's
Lane
what
Brooks.
it is.
Brooks.
I disagree entirely. The concept of ex parte contact is only applicable when there's an adversary proceeding. If the probate is purely an administrative proceeding, the wrongful death beneficiaries or the heirs or devisees are not parties to the probate case. They're not in the caption. The PR always gets to talk directly to the probate court without letting the beneficiaries know about a variety of things. We don't serve the inventory on the beneficiaries. That's ex parte contact.
At what point in the probate does it convert from an administrative proceeding to an adversarial proceeding?
It's funny.
When somebody objects to something, the PRs ask the court to approve.
Right, and if you don't even get notice.
It's funny. I can understand go ahead.
No, you have to say what it is.
Go ahead, Bonnie.
Okay, sorry, I don't mean to interrupt. You know, I can understand the, you know, concern with providing notice to the beneficiary. So from the standpoint of a personal injury attorney, we're looking at it as, okay, our adversary is the insurance company, basically, or the defendant, right? So that's our adversary, and it's a very, it's a hard-fought battle. And when you get to the end and then you settle, you know, that particular adversary is going to appear in front of the court possibly as well. So, you know, it's not ex parte from that perspective. And the beneficiaries, while they may not always agree with it, to me, you know, everything, the justice has already been met by having that adversarial position between the plaintiff and the defendant in that wrongful death action. And then all the things I think that Jennifer was mentioning, I mean, you have quite a few things here that you have to justify as a duty, you know, your fiduciary duty to the PR and the PR's fiduciary duty to be able to justify that settlement with that list, that laundry list that we normally don't have to do. So I think that's enough protection.
Yeah, I mean, again, I'm persuaded, I think we were writing this from, on a clean slate. I'd be more persuaded, I think, by Heather's argument, but we're not. And I think we just had to accept that.
The current case is.
That's right, yeah. So do we need, in that case, do we need to say in here that, do we need to say affirmatively that the petition need not be served on the, so that it's clear? Otherwise, I would serve it, just because that's what I do. But if the point here is that it need not be served.
This is Jim Hughley. I agree with that. And the reason is courts around the state are inconsistent with what they ask us to do. Some probate judges say, well, the case is being settled. You filed a petition and declaration of reasonableness. We would like you to serve that upon the beneficiaries. The beneficiaries have no standing to object one way or the other, but some judges believe that that's probably the best thing to do, and they do that. So I think it needs to be affirmatively stated that we have no duty, there's no requirement to do it, and I think it'll relieve some of the pressure that the judges have, that they feel themselves on what they should be doing. That's just my
I think what's difficult about this probably is having to be explicit about saying that in a statute. I guess it's one thing to be aware that it's happening, and okay, we kind of look askance at it, but to put in the black letter that, you know, the petition does not need to be served on, you know, beneficiaries, that kind of makes my tummy twist. But I understand, Jennifer.
Well, so are we gonna have pushback from the judges? There are some judges who think there should be, we're between the PI defense bar and, PI bar and the justice.
I know a judge will show up in her robe one year. Walk down the street and she successfully tanked other legislation that I spent the numerous hours. So
That's a good point. And would argue for, let's go for it. We're gonna, we're either gonna succeed or we're gonna lose. And, maybe, I'd like to,
maybe we end run it by we are silent in the statute.
Well, I was just thinking about that myself.
Plaintiff bar, and instead we have really good legislative history notes. Talk about what we discussed and why we discussed it, and we hang our hat on that case.
Jeff?
I just want to raise the settlement versus apportionment
Yes.
thing one more time.
Yes.
Because, sometimes it's a petition for both at the same time. Approving the settlement and approving the apportionment.
Sure.
And if there's anything about apportionment in there, judges are going to require notice.
And I think that's
for good reason.
Yeah.
And we frequently see issues where people don't distinguish the ORS 30 beneficiaries of wrongful death proceeds from the heirs that are listed in the petition. Now, there is some notice provided to heirs because they're getting the information when the PR gets appointed.
Right.
And typically the petition says pursuing wrongful death.
Right.
So that
you won't hear from me again.
Element of notice.
Yeah, right.
Potentially people could get involved in either the underlying litigation or get involved as like an interested person entitled to notice by appearing in the case.
Yeah.
But I don't know how we address that in statute to distinguish between approval of the settlement amount versus the apportionment.
Okay, that's a good point. Let's save that for a second. I mean, Heather, you suggested something that's a little bit unseemly, but it may be the way we have to do this. Yeah. That we just remain silent, that we leave the statute as it is. That doesn't say anything about service, but it says that the affidavit is confidential and you know, we've solved some of the problems, we haven't solved everything, and we move on. Gretchen?
We still have not addressed the personal injury definition issue. Here is still regarding the confidentiality versus what our.
Okay, so tell me that again.
It says that when they petition for approval of settlement of a personal injury claim,
Right,
our definition of personal injury claim does not include wrongful death.
right,
So arguably, if it's a wrongful death,
Right.
there's no confidentiality.
Shannon said that was by design, right?
That's what?
Shannon says that's by design. Shannon, confirming, is that right, that the bill last session was not intended to exempt affidavit of reasonableness in a wrongful death case?
It wasn't included in the statute, and it was, the parties did realize that it wasn't including wrongful death, and that maybe that could be corrected at some point, but it was just trying to address the personal injury side. And, you know, really that statute was pushed forward because there was the injury itself was confidential, and there was a lot of personal information about like minors who suffered sensitive injuries that were having to become public record, things along those lines. So it wasn't just the amount of settlement. And so as to someone had deceased, then assumedly, you know, those injuries become less personal. That was the thought, I think. So, yeah.
Bonnie, I have a question.
Yeah, but
this is for Jim. This is Bonnie Richardson. Jim, I wanted to sort of have a discussion about this confidentiality part.
You bet.
I understand that it is, right now, under that current definition that you have proposed by the House bill, it doesn't include wrongful death. So in other words, an declaration that's filed under this statute would not be confidential for wrongful death cases. And I'm okay with that, you know, because I can tell the other side, the insurance company or the defendant, sorry, which I'm doing right now in settlement negotiations, you know, it's not confidential. And that is okay, but I'm thinking that the defense bar might want that to be confidential. So I wanted to see what Jim's take is on that.
Really appreciate that question. Here's the reality from the ground. Let's assume we settle a wrongful death case and the court agrees to the settlement and finds it to be reasonable, but somebody wants it to be confidential. I will have a father, a mother, and 7 children in various states who will be the beneficiaries of that money, as well as a widow. What are the chances of all of those people not telling anybody what the amount of money was or what happened? It is fundamentally 0. So having a confidentiality agreement and having any teeth or being able to enforce it whatsoever in a wrongful death case is impossible. It can't be done. So
well, and again, for the same reason, I'm sort of inclined to take your wisdom on the issue of the confidentiality in the PI. I'm also sort of, I'm not feeling like opening up that battle again from last session. Let's just leave it. It is what it is.
Let me also say that in all of the years that I've done this, I have had defendants in wrongful death cases say, I want it to be confidential. In every case, and I will estimate I've probably handled 200 wrongful death cases, at least. In every case, I've told them the statute does not allow it to be confidential. It is public record. We have beneficiaries who are going to discuss it. I'm sorry, that won't work. I have never in my career have a case fall apart because it's not confidential, ever.
All right. So after that, I think the language of section 3 sub 1 works. Huh?
I knew it.
You knew it. All right. Then let's go on to 2. No, but this is good. You had to persuade us. We're probate lawyers here, and that's why we invited you to the conversation. So thank you that you've made us uncomfortable, but you know, it's not a perfect world. Don't we know? Sub 2, a petition to approve settlement must be accompanied by a declaration under penalty of perjury of the attorney for the decedent in the PI action or the attorney for the beneficiary in the wrongful death claim. For the beneficiary, attorney for the beneficiary. It's still the PR, isn't it?
Yeah.
Yeah, it's not the beneficiary, you're the attorney for the PR.
Something weird about that other statute that required us to do that.
Really?
This is Shannon. Oh, sorry.
No, go
Someone
ahead.
else first?
No, you're first.
We use this inconsistently throughout the, proposed statute, like on change to section 6, sub 1C, we say the, attorney representing the personal representative for the wrongful death action. Then if you go down to sub 6C, we say the attorney representing the plaintiff in the wrongful death action. I'm wondering, I think that the attorney representing the personal representative of the wrongful death action or wrongful death claim would be a good, consistent way for all three of those.
It seems to tie in with the language of chapter 30. That says, because it's the PR that brings a wrongful death claim on behalf of the beneficiaries.
I agree.
You can use the PI claim after the death.
That's right, yeah. So let's make that PR.
Yeah, and make them all.
Okay, so it's gonna be, okay, so that's who we're identifying as the attorney for the PR.
Does that include the clause just prior to that? We have two different attorneys that could possibly provide this affidavit. Attorney for the decedent in a personal injury cause of action.
Yeah.
But once they're deceased, doesn't there have to be a PR in order to resolve that? So
They're always the same lawyer, right? There's the injury or wrongful death lawyer and then.
Okay, that's true.
But they have to be the same lawyer because at the point the victim of the PI claim begins, and they die, the PR has to.
The state lawyer might not know about the tort or.
But this is being filed in the probate proceeding. I mean, the way I've done it before. Yeah, just like Brooks, the way I've done it before, you know, I got a PI lawyer doing the wrongful death claim. I just have him give me the affidavit and I prepare the motion. And so I'm the PR, I'm the lawyer for the PR filing the motion, but I'm relying on the lawyer handling the PI, the wrongful death case, to actually marshal everything that I need, but I'm the one filing it because I'm the one on record in front of the probate court.
aren't they both the lawyer for the PR? Because the PR.
Okay.
The PR then.
Sure, I guess that's a good point, yeah. I've associated some, or usually they've associated me.
I think you just say under penalty of perjury of the attorney for the personal representative in the personal injury cause of action or the wrongful.
I think so.
And that way, because I was uncomfortable with having an attorney for a decedent, that's confusing.
Yeah.
And it could be that the personal injury claim isn't brought until after the
Yes,
decedent dies.
right. Okay, so we make those PR? Okay.
And then
Brooks?
instead of personal injury cause of action, we can, sorry.
Oh, no, what?
Oh, and then we say personal injury cause of action, that probably should be personal injury claim.
Oh, you're right, because, claim is the defined term.
Yeah. Is that the same if the claim is survive, you know, if there was an existing claim and then the person dies?
Yeah, still the PR, because it's a PR asset, it's an estate asset.
Okay.
Carry on. I might be back. So let's go on down that list.
All right. Where were we? He's gone, but you can go ahead.
Let's the bill.
Lane had to step out, but, you're next.
Yeah, it said something about
I
first degree attorneys had departed, I don't know.
Brooks, you're welcome to.
Yeah, so I drove Lane away, good to know. I don't know that controversy matters because I agree there are often cases when you have probate administrative counsel and PI counsel, like in Jim's Blackwell case. Tim Nay's firm is doing the estate work, Jim did the PI work, the wrongful death case. Whoever's going to sign the declaration has to have personal knowledge of it. They both represent the PR. I don't have a problem with a declaration signed by the Jim Hughley guy, who's not counsel of record in the probate, getting filed as part of all of this, because it's going to be the Tim Nay guy filing the petition. And if Jim's the one with the personal knowledge, that works. They're still both counsel of the PR. I don't see a problem with any of that.
And I think that's where we ended up, Brooks, is that we just
Agree.
call the counsel for the PR, since both of them
Yep.
represent.
So
Agree.
if we're going down the list on D, where it says stated amount of prayer, I think that should be clarified. I mean, that that's a little confusing, because it's possible there was no action filed, is that possible? Or,
Yeah.
so wait, what, the prayer of what?
Well, the prayer is a civil litigation term, and that's the prayer at the end of the complaint. If there was no action filed and the settlement occurred before filing, you're just going to say we didn't file a complaint, so there never was a prayer. I mean, I don't see how that can be otherwise.
Stating the amount of the prayer in any litigation file?
Or stating the amount of prayer, if any.
Well, don't
Yeah,
you?
but there never is a prayer except in a pleading.
Right.
That's a term of art.
Isn't the point of D because you want the judge to know how much you were asserting a right to? So if you didn't litigate, don't you need to identify the amount of the initial claim?
Yeah, you could say prayer or initial demand.
Yeah.
I'm sure I really like this prayer word.
I'm not
Use
sure,
that.
yeah.
But,
Prayer needs to be the complaint form, prayer of what?
No, I like prayer, it doesn't bother me, but I do think that
I think
the
we
problem
need
for
to
the
add
probate,
initial claim.
yeah, the problem for the probate lawyer is that when we have, a puffer who says, oh, it's worth $3 million, and we're selling for $100,000 because he was wrong, I mean, it just looks so funny. Anyway.
But they might do that in a filed litigation.
They do that as a complaint anyway.
Yeah, and, courts, I mean, we see that you're used filing all the time.
So now,
Because then as you drop down to the rest of it, even if there is the, $100 million or whatever it is, you're explaining to me why the 100,000 increase is, that's where it is. So I'm kind of like, okay, it's good.
Well, so why don't we say state the amount of the prayer in any complaint or initial?
in any demand or initial demand.
Bonnie, how about just stating the amount of the claim? Then, because often it gets amended, so sometimes you have an initial claim and then it's amended later, and you can make it broad by just saying the claim. Is that okay?
Claim for relief?
Well, it's not claim for relief if it's not filed.
Well, yeah, we need to address both of those because it's not a claim at all, right?
Well,
So we don't like
it is
prayer.
filed litigation.
Yeah.
Then the order approving could be called a benediction.
I know that. These are all old, but I think everything that Brooks is right, it's a term of art, we all know what it means.
Yeah.
But will Joe Blow know?
Yes, but we don't.
Joe
use
Blow's
it
not gonna read this statute. Prayer, I mean, a prayer is a term of art, right?
Mm-hmm.
Okay. All right, stating the amount of the settlement. The amount of attorney fees. In fact, don't we even say praise for judgment? Don't we still say that in complaints? Yeah, right, yeah.
We do.
So, yep,
I
that's,
say request now.
oh, do you really?
Well, I guess my point, I
should never have started.
Prayer, it just needs more, the prayer in litigation, or it, by itself, it's an unclear term.
Do you think
I
so?
disagree.
Yeah, I think it,
Oh,
I think lawyers
But
understand what it
you
means.
wanted to have or demand,
Are we modernizing?
or initial demand.
Or initial claim, I think.
Because it may not be, if it's not a complaint,
Right.
yeah.
So if they never have had a complaint, then just go back.
We actually do use request for relief all over the place. So how about request for relief? Does that make anybody happy? That's where,
It's a claim, isn't it?
Why aren't we just using claim? Because doesn't that incorporate
A
both?
catch-all and modernize.
Claim could be outside of.
Litigation,
Yeah, outside of
okay.
litigation.
Well, and that may be augurs for not using prayer because these won't always be subject to, they won't always have been filed. Okay, claim, done.
modernized, good job.
We've modernized it.
Yeah, no,
That's right.
we said it, but I like it.
Yeah. And now,
Modernized doesn't
now on
mean
Sunday
that we
morning,
need
the pastor would say, let us claim. Amount of the settlement, amount of attorney fees and costs, proposed disposition of the settlement proceeds. Now, this gets in, we'll come back to that. The reasons for settlement, efforts to maximize efforts.
Oh, I have a
Attorneys
comment
in-
about G, this Bonnie.
I do too. We'll come back to that,
Okay.
Bonnie.
All right.
It's gonna be.
So do I.
harder. Yeah, I know. That's why I'm coming
Okay.
back.
Just making
Stating
sure.
attorneys have evaluated the interests of the estate and beneficiaries. stating the attorney has examined the applicable medical records, whether the attorney has consulted, oh, this is the new part, right?
Yeah,
'Cause-
right? No, well, where does that end up?
Oh, that's not, okay. Oh, you're right, okay. But stating whether the consulted with, Rick and Gretchen and Matt. So let's go.
Put that in the statute.
Yeah. With, so, Judge,
Are we to L yet?
yes.
What is necessary?
Okay, let me ask Jim and Bonnie and Brooks and Shannon, what is necessary and proper? We're referencing the language in sub L.
I was gonna ask the same thing. I mean, I feel like it's similar to H.
I see it as duplicative, I agree.
Okay,
So I would argue that stating, that it's appropriate to settle. Because that's the attorney putting themselves, in my mind.
that's sort of the ultimate conclusion.
Exactly. You're putting.
In view of everything before this, it is appropriate to settle the case.
Exactly.
All right, let's do that. And to me, that ought to be a pretty easy conclusion to make once you've worked your way through A through K. Based on all the foregoing, I certify it as appropriate, the case be settled as proposed.
And that's when I'm looking for when the attorney says, I'm finding this,
Yeah.
this is appropriate.
All right,
I agree, I like that language.
wrongful death people, you okay, all right. Okay, let's go back to G.
I think it has to come out when I'm getting those.
Agreed.
You want me to explain some of the,
Communicate my rights without my opportunity.
Yeah, this is specific to wrongful death proceedings, and this is the apportionment. And so I think.
It also talks about the payment.
Yes,
reimbursement,
yes, right.
credit.
So are we all agreed that G comes out? Okay, I don't hear any objection to that. Then do we need to add a statute about the petition for, apportionment?
I have a thought on that, Lane.
What?
As Chapter 30 currently exists, the probate court or the trial court, if you tried it to a judgment, is the court that will determine apportionment. Unstated in that is that if all the beneficiaries are competent adults, they can make any agreement they want.
Sure. Yes.
So I think the scheme already assumes that once we have net funds after the PI lawyers paid, et cetera, everybody's going to talk about it. And if they can't come to an agreement or we have an incapacitated person, et cetera, a petition will get filed. So I don't know that we need to say that again. I mean, if you look at the statutory scheme as it exists, it has to be that way as it's currently written.
Yeah, conversation about that?
This is Jim Hughley. I absolutely agree with that comment.
Okay.
From the courts, anecdotally, I think that requires you to put a bunch of faith in the people reading the statute. To have them realize that it could be two separate petitions, or one, or even to interpret who the beneficiaries are.
Well, geez, yeah.
Is Brian there, or, was that, Multnomah County?
Yeah, Brian, no, that was, that was, Jeff is Multnomah County now, geez. And Brian is here,
Well, so this language was just taken from the SLRs in Multnomah County. And so I'm glad to hear from Jeff, and I would be interested to hear from Brian too, 'cause I think this was potentially added during his time there about, both L and G are in the SLR. So if you're in Multnomah County, potentially we may have to include that language still. I'm interested to hear more from them. Sorry, could you hear me all right?
Yeah.
Yes, and your baby.
Oh, sorry.
No, that's okay, sweet.
So.
Brian is gearing up an answer, Shannon.
Oh, great, okay.
Well, in the SLR was written a long time ago, and I don't know that it, that it doesn't need some revision too.
But as far as G goes, I think it's just because a lot of times when the settlement is approved, part of that settlement is the payment of doctor's bills and other things that come in as part of that, and so that's why there's that request that be explained as well, and that it come along with it. I don't think that it necessarily means that it has to cover all of the apportionment, but at least it will cover those pieces that were made as part of the settlement.
How about if we are really specific and we say, 30.030 paren 3?
That's what it says, actually.
Well, it
Okay.
says include,
Yeah, including, yeah, that's right, because you're right.
if we
Oh.
want to exclude apportionment,
Yeah.
we could make this clear, say that the petition for approval must state the distributions that will be made on.
Payments or reimbursements owed under, yeah.
30.0302 and 3. 2 is, attorney fees and costs, and 3 is the medical expenses related to the injury.
Well, we got attorney fees and costs in F, just before that, yeah. All right, well, there's the
So
thought.
this is Bonnie, and so I had a comment about that part of it.
Yeah,
Okay, so I just want, and feel free, Jim and Brooks or whoever over there to weigh in on this, but this is, a lot of times what happens with these wrongful death cases or personal injury cases, if you settle it, you kind of figure out, okay, what's the settlement? And then what you do is you negotiate with those doctors on those liens. So you might
Right.
have an amount that you set aside. Obviously, you have to set aside that amount of the estate in order to pay it. But then you want to be able to have the ability to then negotiate down what is owed. And a lot of times you use the fact that you had to settle for significantly less to get
Right.
them to come down. And so I just want to make sure that we're not sending a message out there that, somehow all of that money is then going to be made to pay all of the medical bills, when in situations like this, we often negotiate them down.
No, I don't think, that's a good question. I don't think, and maybe we can have a comment on this as well. I don't think that's the intent of this, if you've negotiated, just show what you've negotiated.
Lane Brooks.
Negotiation might not happen until after you've got the settlement
Right.
approved.
Oh,
Yeah.
I see.
I'm on the receiving end of this.
Oh.
We have to say, we settled, we got, 50% on the dollar for our claim.
Okay.
We want you to take
10 cents on that.
I see. Okay,
And we say no.
so that is problematic,
But
maybe.
well, what I see all the time is the petition says, we're setting aside X dollars for these potential liens, and we will negotiate those, and either pay them or settlement.
Are the
Lane Brooks.
liens?
Just a second, Brooks.
I don't think they are.
What's that?
The liens are not considered the apportionment, right?
No.
The apportionment is
No.
the net.
To the beneficiary.
Yeah. So
Right.
I don't, if there are lien holders, that's something the court obviously wants to know, like how you're assigning your costs or your, to get to your net.
Maybe we say the personal representative shall advise the court that they set aside an appropriate amount for payment and reimbursement of.
Well, there you could say, stating the amount set aside for payment and reimbursements owed under 30.0302 and 3, or 3.
Set aside an appropriate amount, not because, yeah.
Was that just, I think Brooks was in line on the phone.
Thank you, Lane. I'm strongly against including anything that makes the PR talk about medical, funeral, hospital expenses for the following reason. Number one, the way I read Chapter 30 now, the PR has an affirmative duty to go to each of those people. And it's not that these people make a claim. It's the PR says, hey, I've got cash on hand. Your bill's $100,000. I'm going to give you $100,000. What happens practically is exactly what Bonnie said. We use every tool in the toolbook to try to get the medical providers to take less than the face amount of their bill. And we often are able to do that. Putting anything in that says I've reserved $500,000 or I've reserved a big pile of money or anything binds the PR into a weaker settlement position, which harms the beneficiaries.
Yeah, I
binds the
get
PR
that.
into a weaker negotiating position with the providers. That's what I meant to say. Thank you.
I don't see how it changes. I know how much you owe me.
Yeah.
And I know that you settled and that you have an obligation, but I don't see how, I mean, if you're in Multnomah County, you're already putting this in. Hasn't
Yeah,
changed. It's cool.
It's not so much you, it's not so much you, Rick, it's the private medical expenses that were paid by a private insurance or other source like that, where we have a lot of room to negotiate with them, and making the PR say these sort of things lessens the PR's position, which I don't like.
But I guess the question, Brooks, is, if this is the rule already in Multnomah and Clackamas counties, Brian says there's never been any pushback on this. So we're not creating something new here. It's been in existence in two of the largest counties, and Multnomah in particular probably has the majority.
It's news to me that that's the rule in those counties, because I have never put this in a petition for approval, and I've never had one rejected. No kidding.
I don't see how you can not set aside enough money to pay all of the creditors. You have some duty to them, and usually the money's sitting in your trust account. And you have an ethical duty to notify anybody that you have funds in your trust account which they may have a claim against. How do you, I mean, I don't see how.
That's not what I'm saying at all.
Set aside enough funds to pay all the creditors in full.
Brooks.
That's not what I'm saying at all. Let me give you a hypo based upon what happens on the ground. We settle for a gross amount of $1 million, whatever the number is. PI lawyers, attorney fees, because they're exiting stage left at this point, get reviewed and approved by the court. They take their 25%, their third, whatever they've earned. Litigation costs get paid back because those come off the top. Then we're sitting on a net pot of money, some of which may belong to you, Rick. It's at that point that I use every persuasive ability I have to call you up and say, look, I know your lien, your claim, use the word you want, is $400,000. But here were the problems with the case. This is why we got less than we thought we should be able to get for it. You know, if you take all 400,000, then the little, you know, the orphans aren't going to get as much as I want them to get for college. And I try to persuade you and everyone else to take less. It's not that I'm not setting aside money. It's that making me say this in a pleading, in my view, you know, puts me at a negotiating disadvantage. But I agree with you ethically. I've got to come to an agreement with you that you're going to take X dollars, whatever those are. Otherwise, we're stalled. Because until I have a deal with you and with Providence and with OHSU, whoever it is, we can't move to the next stage, which is apportioning the net amount. I agree with that. But I don't want to have to say, Rick wants 400 grand. I'm going to set aside 400 grand for Rick, because that puts you in a position to say, great, give me the 400 grand, which is your obligation to your client. I want to try to persuade you to take less. I just don't want to be bound with this.
A question that just occurred to me. If this document is confidential.
It's not in a wrongful death.
It's not in a wrongful death. Okay, my mistake.
So let me ask, this may be arguing about not much, because, I mean, I understand your point, Brooks. If you say, because basically what you would have to say in G, you would have to say that you have set aside an amount equal to all of the medical expenses that have been, you know, that are out there. I mean, because at that point you can't assume, unless you've already negotiated, you can't assume that you're going to be able to, you know, negotiate a less than full payment of every claim that's out there. So you would just have to say in this that you have set aside this amount, and it's the total amount that's owing to everybody. And your position is that at that point, then you've basically given that money away to the creditors, because you've already told them that this money has been set aside to be paid, and it's coming out of the distribution ultimately to the beneficiaries. And I think your point is the statute already requires that those claims be settled. And so does it really mean anything to put the sum total of all the claims that are out there in this affidavit? Would it be enough just to say that the payments or reimbursements owing under ORS 300303 will be paid? And
I don't want to say will be paid. This is Bonnie. Sorry, this is Bonnie. Okay, don't want to say will be paid, but you know, I can understand. Well, I can understand that we do need to say something about the amounts, because the judge is going to want to know, the court's going to want to know what amount is being put aside to pay liens. So I want to just make a clarification here that there is no ethical duty to creditors for personal injury attorneys to pay those creditors unless people assert that they have a disagreement about funds that are sitting in your client trust account. But there is statutory duties of lawyers that we have to make sure that liens are paid or negotiated down, taken care of. So if I would rather see liens, and not have any mandatory language that they be paid, and I don't quite know how to come up with the language.
Well, what's the language in 0303? 300303. Just, can we just incorporate that language?
Reads, the personal representative shall make payment or reimbursement for reasonable charges necessarily incurred for doctor's services, hospital services, nursing services, or other medical services, burial services, and memorial services rendered for the decedent.
Well, so would it work to just simply list those amounts that are currently owed? And of course, they have to be settled and paid before, just say, here's how much it is.
This is Jim Hughley. If I just make a quick comment. First of all, I really appreciate you helping on all this, and I do appreciate being asked to participate. The reality is, in most of these cases, before we settle the case, we are involved extensively in negotiating all of these liens down, because we can't settle the case unless we know what we're going to have to pay in the form of liens. So let's assume we get an offer for $1 million. We will not accept that offer. At least this is the way I practice, and I think most people that do this practice this way. We will then immediately go to the lien holders and say, look, you've got a lien here for $50,000. The claim is really worth $40 million. There's only $1 million in insurance. We want you to take a haircut on this and accept $5,000. And we'll get a yes or a no, and then we'll continue to pare down those liens until we find out exactly what the actual debt's going to be. Once we have all of that down, we can then enter into serious settlement negotiations and get the case settled. I can't recall a case myself where we've settled a case and just allowed all the liens just to hang out there without any type of pre-negotiation. That's my experience.
Yeah. So Matt, you seem to describe a different scenario.
I have seen cases where the petition identifies the lien, so it identifies DHS and their lien amount, identifies the CCO that may have been providing the services and their lien amount, and then says that the attorney is, set aside funds in that amount and will negotiate or resolve those liens.
How about this? If in G, what we get at is you list the, because you list the charges entitled to reimbursement, to be reimbursed under 30.0303, and affirmatively state that the attorney for the PR will comply with 30.0303.
I don't like that.
Why?
I don't think a judge is signing an order approving a settlement without a number on those things. And like in Multnomah County, I've only been there a short time, but DHS has to get notice before a judge is ever going to sign a settlement order. So I don't see any judges, at least in the two counties I have experience with, signing off on an order approving a settlement with an amount TBD paid to. Well,
and Jim says, in his experience, that's all negotiated before you file your motion to approve the settlement anyway. Is that what you said, Jim?
That's generally what we do, yes.
Jim, this is Bonnie. So you have way more experience than I do on personal injury and wrongful death, but I see lots of files of like smaller cases probably of personal injury attorneys. And it's, while your practice is the best practice, and I think that is great, I think most, unfortunately, most PI people are often try to get some of the liens maybe negotiated down, but a lot of them just do it afterwards. And
here's
they
the
use
problem.
that fact.
Bonnie, here's the problem with that process. I have an absolute fiduciary duty to the estate, not to Jim Hughley. That's the problem we run into in a lot of these cases, is that the lawyers sometimes lose track of what they're really supposed to be doing. And we have a duty to make the estate as large as we can when we leave it, not simply to take our attorney's fees and then cut the estate loose and let them sort it out on their own. So, I just think that we have a duty to do that. So, putting a pot of money in and saying go after it, I think is inappropriate. I would try to leave it as general as you could, and the way it's worked so far in the last few decades, the way the statute's written, is pretty effective, and everybody does it in their own way. So I don't see any significant change that I would feels necessary.
Judge Brooks. Okay, Brooks, let me get Judge Cobb in first, then you.
My question is, if you don't know okay, not down to the penny, but how are you gonna tell me this settlement is reasonable if you don't know what you're paying your creditors? And that's why Jeff's point about looking for numbers, we're all looking for numbers because I've only got one side here. They're swearing to me this is reasonable. How am I evaluating this and protecting everybody else there if I'm getting pat on the head saying, don't worry about it, Judge, we'll work it out later?
Brooks.
I'm echoing Bonnie's comment very briefly with a little addition. I agree that Jim's method of practice is without question the gold standard for PI wrongful death lawyers. There are a lot of times when the medical the medical bills are known, but the lawyers have not engaged with medical providers prior to seeking authority to accept a settlement. That happens a lot. So just back to my comment, putting something in that says OHSU says they want X dollars, that doesn't bother me. That's a fact that everyone already knows. But going further and binding the PR to say, I've got the money set aside or this much goes to them, again, reduces our ability to do the post-settlement negotiations, which, Jim, unfortunately, we get involved in a lot. I don't agree that it should happen, but it does.
Yeah, that's true.
I have a comment from,
Well, there's two. One is that with the PIL lien, there is personal liability for the attorney if they contribute the money without first paying the lien. So that it's not just a statutory obligation. And I've sued attorneys for that. So, and received judgments.
Jesus.
And, sorry guys. So it is a very high standard to pay those liens. It's not just we're gonna work it out after we settle it and try and get you down. The other thing is, frankly, just from a practical standpoint, I know how much you settled for. Putting that into, I'm gonna assume you have that money available. I am going to assume it's there and that you're gonna pay me the full amount. And then you are going to try and negotiate saying, well, actually it was worth more. We've got, widows and orphans and puppies and kittens that need this money and try and get it down. But the fact that I know I know that money's there, whether it's in a pleading or not, I'm going to assume as the creditor, you got everything available that you settled for me. So the fact written down in a piece of paper to me doesn't affect negotiation from a creditor standpoint.
Brooks.
Judge, it's the rare circumstance in my experience that creditors actually go to the probate file and look at this stuff. What happens in my experience generally when I have one of these unfortunate, it got settled before we negotiated, is I call up Providence or whomever, and then I start telling them about it, and they don't know. And they learn what it is that I choose to tell them. And I agree, I can't make misrepresentations, et cetera. But I don't agree that everybody starts out with the same amount of knowledge. That's not my experience.
Jennifer.
Well, so if a settlement occurs and it's subject to court approval, why not just make the people deal with all these medical things before they seek court approval? And then that way the judges know, here's the numbers, everyone knows.
Yeah, it sounds like that's the gold standard, but we're swimming upstream to mix a few metaphors.
Why are we going to the lowest common denominator?
Well, okay, all right. Brooks.
Just very quickly, in the movement of civil litigation cases with trial court pressure to get cases resolved, et cetera, everything doesn't always happen in the order that we want it to because of a variety of factors. I am very uncomfortable about building in something that says before you ask Judge Cobb to approve your settlement, you must pre-negotiate with OHSU.
Yeah.
The fact patterns are too varied for that to always be correct.
Okay, so again, let me ask, we're gonna have to work out something here. Would it be a starting point for a suitable compromise here to at least list what those claims are that are due to be reimbursed under 30.0303? You have to know that. State those amounts and say that you'll comply with 30.0303. And that doesn't say you're gonna pay all of them in full. It just tells Judge Cobb sort of what the size of the universe is here against which she's measuring the gross settlement, and gives her the ability to call up the lawyer or say, wait a minute, there's a lot of claims here, not much left for beneficiaries, what are you gonna do? And that gives her the option, the ability to satisfy herself that, okay, I guess this is reasonable, or not. And maybe that lawyer, that hapless lawyer, needs to do some more homework before that settlement gets approved, so they don't get sued by Gretchen, because they've at least put the judge on notice of the information that allows her to ask that question. How about that?
Well, the way this actually plays out, and those people who aren't the gold standard like Jim, is they state, as this says, that what the disposition of the settlement proceeds are, and as, if you read it, it says, the payments and reimbursements owed. It doesn't say exactly what they're going to.
That's right, that's right.
How much is owed.
Yeah.
And what they do is they then say, this is the settlement, this is what we owe, we haven't negotiated with them completely yet. And then when the enforcement comes through, then they explain what they're going to end up paying to them. So you don't have to have that all figured out now.
No, not the settlement, but you need to know what the amounts, what the gross amounts are.
Those parts,
And
that's
you've gotten the
actually
bill,
even
you've
in the
gotten the
SLR.
claim, you know how
Yeah,
much is owed.
well, maybe it should be, but we're not writing the SLR, we're writing our own damn statute. So, but I'm offering that as a middle ground here, that you tell the judge what those expenses are that are reimbursable under 0303, and that you will comply with 0303. It doesn't commit
Bonnie.
you. Yeah, Bonnie.
Can I make a proposal on language and just put this out there? I don't know if this is even good or not, but if we say any payments, or any liens, can we add liens? Is there any?
Well, it's 0303 is broader than liens.
I don't see 303, I don't see it applying to liens. I mean, maybe it's just inferred in there, but I mean.
Oh, okay, so maybe be liens and damages, and, okay, so maybe it needs to be both.
Liens payments, reimbursements, rather than say owed,
Okay.
I mean, set aside pursuant to ORS 30.030.
We're not asking anybody to set aside anything, just say what those are, so that the judge can look at that and say, okay, I've got this much in the way of liens and expenses that have to be reimbursed under 0303, we got a settlement of this amount, does that cause me any concerns about the reasonableness of the settlement? Assure me that these, there's gonna be something here that's left for beneficiaries, and doesn't that work?
We have a comment that says that we intend to not limit any post-judgment.
Settlement negotiations, right, yeah.
I think we need to have that comment.
Well, I guess that's why I was suggesting that, 0303 be complied with, because all that means is life goes on. We're not changing anything, because we're not changing 0303. Can we get to some comfort? There will see language, but the concept would be that the affidavit lists liens filed, and lists liens and amounts reimbursable under 0303, and says that 0303 will be complied with.
Do you want to keep stating the proposed disposition of the settlement proceeds?
No. Yeah, that's right. Yeah.
So just state liens.
Liens and reimbursable expenses.
And reimbursable amounts pursuant to.
0303.
Yeah, and will comply. And statement.
Why do we want to say and comply with?
Yes, and comply with.
Why
Yeah.
though?
Why?
Why add that? Just, isn't it
Why
inferred?
There's my answer.
I mean, I feel like it's in there. I don't know that we need to add, and comply with 30.030.
Maybe not. maybe not, because the statute already has its own affirmative obligation. I could take out and comply with. Because we're not, this is, I guess it's one thing if this is the statutory form for small estates where we're talking to, you know, people off the street. Here we're talking to PI lawyers, and we're calling their attention to 0303 and these liens. That should be enough.
Yes, thank you.
What are the liens? I don't know. Bonnie's talking about liens.
I just say liens, go ahead, Brooks.
Are there liens that would not be, are there liens that would not be expenses that are reimbursable under 0303?
That's my question.
Yeah,
There will not be.
okay.
There will not
So-
be. And just to be hyper-technical, these aren't liens. These are
Okay.
obligations the PR has to offer payment, even if the creditor doesn't ask for it.
Okay, so let's just go to 0303 then. That'll be the reference point. Huh,
But
what?
you know that.
I
You know
know.
that.
Yeah,
Yeah.
yeah.
You're also
But-
a medical.
So we-
But that's what I'm saying. I think the universe of 0303 is broad enough to cover liens.
I didn't want our including liens
Yeah.
to suggest that there could be
Something else.
that's payable
Yeah.
because
Okay.
payment is under 3003.
Brilliant. I think we got there. This
Okay.
is good. It's hard, but it's good. Okay, let's,
Object now.
you, no.
You can only object to final count.
Oh, okay.
Yeah, that's right. That'll be the hearing. Okay, section 4. Let's move on. This is good. We may not get past the
Well,
statute, but
this is Bonnie. Sorry, one more thing on J. Sorry I probably should have brought it up. So I just am curious why the attorney has to examine the applicable medical records. I mean,
Probably because it's in some SLR somewhere.
oh, okay, all right.
But I mean, but, you know, that's a very poor answer, but, what does it mean?
Actually, I think that was the SLRs with all medical records, so we made it a little less broad.
Okay.
Lawyers, do you do that?
Every medical record. That's it.
Every medical record.
Okay, I like this language better then.
That's right.
Never
You don't
mind.
like this? You don't like this, you can have that. Okay.
Yeah, to the bottom saying it's reasonable and appropriate.
If you don't know, I think she's accepted it. Yeah.
Okay, I was just curious why. Okay.
Seeing a worse alternative coming over the horizon, Okay. Section 4, deferral of requirements. If the only asset of an estate is a PI action that has not been adjudicated or settled, or if the petition for a PI, the personal representative is filed under Section 5, that's wrongful death. And no other assets of the estate have been discovered, the court may defer bond requirements. And accept annual status reports in lieu of the annual account. My first question is any of that redundant? No, it's not. That is not redundant of our 2957 because this is an asset. So, but we're saying, okay, so what do we think about that?
Well, would we ever need a bond in a wrongful death case that doesn't turn into another probate or other assets? I don't think we ever need a bond.
I don't know. Wrongful death lawyers, do you file bonds after you have, at any point, a wrongful death proceeding?
Lane Brooks.
I haven't.
I have had courts in the past require the PR of a filed, not yet settled wrongful death claim to bond it. I have vociferously tried to avoid it, but I have had trial court judges do that. The normal practice after we settle and we have net funds is the funds live in the lawyer's trust account as to avoid bond. But I have had judges tell me to bond the prayer of the wrongful death complaint,
This is Jim Hughley.
which is wrong.
Yeah, this is Jim Hughley. I've never had that happen, so
Wow.
not in my career have I had a judge
Me neither.
do that.
And I guess I don't know that I want to make that the standard then.
I
So-
do not
This is
want
Jim- this is
PRs to
Jim Hughley
bond.
again. There's a lot of reasons for that. Sometimes we'll have a wrongful death case where the prayer is $5 million or $10 million.
Yeah,
The PR is the 27-year-old wife who couldn't get a $10 million bond in her
Yeah.
lifetime. So and the expense is huge. So it just doesn't
Okay.
happen in my experience.
okay. So I'm comfortable in taking out or wrongful death in sub 1. Defer bond requirements until settlement of personal, somehow, because this has to work somehow with
Yeah.
both.
Yeah.
So Marisa is taking that assignment. So we will not infer or explicitly obligate a bond requirement in wrongful death, but in PI cases, they can be deferred. And then we accept annual status reports in lieu of the annual account. Are we okay with that then on 4? All right, let's go on to 5. This is probate for sole purpose of pursuing wrongful death. Section 5, any beneficiary, interested person, or the person nominated in the will may petition for the appointment of a PR for the sole purpose of pursuing a claim for wrongful death, except as provided in 4 through 7. A PR appointed under this section has all the duties, okay, 4 because the 4, okay, yeah. Duties of a PR. In addition to the information required under ORS 113.035, a petition filed under this section must include the following, so far as known. A statement that the the petitioner is filing for the sole purpose of pursuing wrongful death. Names, relationship to the decedent, and addresses of beneficiaries. Okay, and beneficiaries is already a defined term. Yep. For the purposes of this statute. And a statement that reasonable efforts have been made to identify and locate all beneficiaries. If the petitioner knows of any actual or possible omissions from the list of beneficiaries, the petition must include a statement indicating there are omissions from the information relating to beneficiaries. Okay, so that is information that goes in addition to what is otherwise required in a probate petition when you are filing for wrongful death only. Comments?
The only comment that I have is a related question. So it's clear what the petition does. I just want to make sure on the information to heirs and devotees, we have clear direction about people who are beneficiaries, but not heirs and devotees.
Can you expand on that?
Yes, so let's say your petition with no assets and you file your information to heirs and devotees because you want people to know that you're.
Well, yeah, because you have to, you should, yeah.
So beneficiaries include stepchildren and parents. They are not heirs and devotees.
Right.
But we waive that requirement. On page 4.
So we waive the information, sorry.
On page 4, section 7.
Well, the next section has the information of the beneficiaries.
Yeah,
But
yeah.
we're coming up on that.
So let's go on. Come back to that. Okay, so let's go on. So you will, okay, no, okay, so, okay, so yeah, so the statement that you have to comply with 113 through the kitchen sink is except as provided in 4 through 7. Okay, we have some.
4 and 7, I think it was.
Pardon?
4 and 7.
4 and 7.
Yeah.
Okay, yeah, right, 4 and 7. Okay, so let's go on to 6. Okay. I was gonna, the last question I had actually, on sub 3, reasonable efforts have been made, and it must include a statement indicating there are omissions. Do we want to say that, well, you've already said that reasonable efforts have been made.
This is Bonnie. I have to sign off, and I just wanted to say thank you to you all, and I'm here and available hopefully for the next meeting, and if you have any questions. But
great, Bonnie. Thank you. Yeah, thanks for joining us.
Thank you. Thank you for allowing me to. Bye.
Thank you, Bonnie.
We want to say here the PR will affirms that they'll continue effort to locate any omitted or missing beneficiaries we care about. Or is that just inferred? Okay, it's inferred. You're going to get involved. Section 6, information. A PR appointed under Section 5, this is a wrongful death only case, shall deliver a mail notice to beneficiaries at their last known address. So there, Heather, that answers your question, I think.
It's beneficiaries, it doesn't include heirs and devotees.
That's correct. They're waived under Section 7. We'll come to them. This is specific to.
Beneficiary does include, under 30.02, I think it includes because.
Oh, that's a good point. It's broader than heirs and devotees.
Right.
Yeah, that's true.
Right.
But, deeds don't necessarily share in wrongful death.
No, they,
Well, if there, I believe if there were excess, which there never are, but if there were excess wrongful death proceeds, then it would go.
excess wrongful death proceeds, what was that?
Lane
No.
Brooks.
Yeah, Brooks.
Any excess wrongful death money, and this does happen, goes to those persons who would inherit the personal property of the decedent under the laws of intestate succession of the decedent's domicile.
So not the.
And that's in 30,
030, paren 5,
Yeah,
30,
yeah.
030, paren 5 says, shall be distributed to the
Yes.
beneficiaries for intestate,
Yep.
described under law.
Yep, right.
Or as agreed by the
I'm just curious, somebody will have to tell me how you get to excess recovery, but not today, we don't have time.
It's not a long story.
I want to know how to do that.
If you take a look at the appellate case of Graves against Culliners, that arose from just that circumstance.
Okay. Okay, let's go, it is the section.
Yeah, I know. Jim, I was
We're
involved long after you'd done your good work.
Yeah.
Okay, section 6, the PR appointed under 5 shall mail the beneficiaries any information, the title of the court, and the case number, name of the decedent, place and date of death, name and address of the PR, the attorney for the PR in the wrongful death action, and the PR in the probate proceeding. D, the date of appointment of the PR. E, statement advising beneficiaries the rights of the beneficiaries may be affected by the proceedings, and additional information may be obtained from the records of the court, et cetera. All right, so that's the first part. That's the contents of the notice. Comments?
Don't put the word clerk's file number in there. The court's number, the case number or something.
Okay.
Clerk's file number.
That's funny. Where'd that come from?
I'm sure it came from somewhere else.
Some ancient statue?
I didn't make it. But, I mean, do you want it to be the same as, let's see if I, the court?
The case number,
Case number.
if we say anything at all.
We personally
The,
don't have our own file number, so.
It's from the thing about the, information to devisees in 113,
And that says,
clerk's
The-
file number.
really? Let's amend that in this. Let's add that as a conforming
I have my own
amendment.
personal file number system over here.
Yeah, that's funny. Let's make that, let's do a conforming amendment on that, fix that. Isn't that great? We can do that. Okay, sub 2. Sometimes when you're reading statutes, don't you wish you could just do that? I'm gonna amend this. It doesn't work for me. 2, if the PR is a beneficiary, name the petition, the PR is not required to deliver mail information to himself or herself. Okay, fine. 3, within 30 days after appointment, shall cause to be filed in the estate proceeding proof. Okay, this is just your basic proof of mailing. And a copy, the same as our standard proof.
This is where we added, VHS.
Okay. 4,
Oh, DSL.
yeah, 4, if before filing the final account, so tell me what they don't have, because I'm looking at the,
In, 3, oh wait,
In 4.
4.
B,
Yes.
you added in, and,
okay, is that the only change from?
Yeah.
Okay, all right, so 4, if before filing the final account, the PR has actual knowledge, the petition did not include the name and address of any beneficiary, the PR shall make reasonable efforts to ascertain the names and addresses of the beneficiaries that were not included, promptly deliver information to each person, and before filing the final account to the Department of State Land. So that deals with escheat,
well, yeah, and TSL is advising they're in a situation where the responsible party was under their jurisdiction. They would be PR in.
Oh.
So, if they need to get notice.
Okay. And file in the estate proceeding on or before the final account, proof of compliance with this subsection or a waiver of notice. The only thing I have there is that we refer to final account in this language, but in section 7, we say that in lieu of a final account, they can, just file this statement. So I think we ought to, it sounds inconsistent. So it'd be the final account or the statement under section 7.
Right.
Okay.
Don't we need a petition to close this probate?
Oh, yeah, that
That's coming up.
That's coming up. Yeah, that's coming up. But so I'm just saying that we're referring to more than just the final account because it may not be, and in many cases probably won't be the final account. It'll just be a statement that the case has been settled and we're ready to close. And then 5, within 30 days after the appointment of the PR, the PR must mail or deliver a copy of the death record of the decedent. Yeah. Ooh, yeah, that's a good hanging obligation.
Oh, yeah.
I just put Jennifer.
It goes to DSL, right? I mean, I'm sorry, to DHS, same as with the proof of the notice in the probate.
I don't know what the intent was there, but if it's to send a copy of the death record to DHS, wouldn't it have been logical to put it in sub 6? Which deals with the notice to DHS?
Oh, yeah, probably would.
I think it came from here, DHS and OHA, or is otherwise provided by rule adopted by the Department
Yeah.
of Authority.
But he's saying that that is, what we send them is under 6. So we don't need to put the death record under 5. Yeah, let's take that out. So again, that's just like the usual notice process in a probate estate.
Yeah.
Which takes us to 6 then, which is notice to DHS. And change the clerk's file number to case number, because we're gonna do that in the other statute. Okay, I think we're there on 6. Any questions?
I do have one request to add.
Yes?
Sometimes the coordinated care organization pays the bills and has the lien that we assign to them. So ordinarily, under the existing statute
Yeah.
for PIL, they're
Yeah.
supposed to give notice to
Oh,
DHS
that's true.
and the CCO.
I have a concern about liens.
About what?
Oh, what is it? Let's stop at Rick's for a second. Brooks and Jim and Shannon, Rick's point is that, you're required, to give notice to the CCO if the CCO has paid. I mean, so should we include, for the purpose of a wrongful death proceeding, should we include the CCO in subsection 6 to receive this special notice?
Lane, this is Brooks. I would be strongly in favor of that, and I'm now going to channel Rick Mills directly. I always worry that the PI lawyers may have missed a bill or something, and giving notice, even if the organization didn't provide the care that could be reimbursed under 30030, is a nice belt and suspenders that we don't have to unmess up when it's all broken at the end of the case. So I'd be strongly in favor.
Okay, stop. We're going to do it. That's right there. No.
Wait, tell me.
Wait, Shannon.
Yeah, I think that, that it is required that a personal injury or a wrongful death attorney give notice, the wrongful death attorney gives notice to the CCOs under 416, and that oftentimes the attorney for the probate matter doesn't know if there was a CCO involved. And so changing that requirement over to the attorney for the probate, I think is misplaced, personally.
Well, how do you guys find out when medical insurance pays the bills that your client incurred? I mean, your client knows, what?
Oh, sorry, go ahead, sorry, Rico.
I mean, if nothing else, the providers know, because when you go out and collect that, you can call the personal injury liens unit and ask if there's a CCO, and we'll tell you. Go ahead.
Oh, well, so this is a notice that's required within 30 days of the appointment of the personal representative. Oftentimes, discovery hasn't even happened at that point. And so we don't know what the medical, what the medical injuries even are sometimes by the time 30 days has passed since the appointment. I feel like the notice to the CCOs is covered elsewhere in the ORS, and putting it here and making it a requirement of the probate attorney, I think it's going to be complicated to actually comply with.
I'll have the probate attorney, I don't have any problem with that. I mean, it's just like DHS. I assume in most cases there's not a lien, but because there isn't, but we send the lien, we send the notice and we tick that box, and sometimes I'm surprised to get a a letter from DHS that there is a claim, the claim, I should say, not lien. And in this case, you just add this, you just send it to the CCO, and you don't have to do any research, because you're not saying that there is a claim, but you're putting them on notice, and I think Brooks' point is, so if there is one, you may find out about it before you make you or the PI lawyer make a mistake. I'm okay with it, Shannon.
Well, I think that it's,
In the state of Oregon?
No.
Is it just one address?
No, there's CCOs all over the
There's
state.
15 CCOs.
yeah, that's the problem.
Did you give a notice to all?
Lane Brooks.
No, just the one that provided benefits.
Okay, then we are having a question. Yeah, how do we know which one that is?
Well, you know,
Lane Brooks.
they,
Just a second, we need to.
Okay, DHS needs to caucus. Brooks, why don't you talk while they're caucusing?
So, as a practical matter, if we're opening an estate for wrongful death only claim, it's really only one of a couple of reasons. Number one, pre-filing negotiations didn't work and we got to file the case, or we're up on a statute, we got to file it in any case, or we can't get access to the medical records without someone authorized to request them. In all of those circumstances, generally, we know a lot about that, about, you know, the medical records situation, et cetera. If we don't, sure, we're going to be beyond the 30 days when we learn that CCO XYZ actually provided care, but a late notice to them that is still an adequate notice doesn't bother me at all. And the final piece to throw in, that was a little bit incoherent, my apologies. The final piece to throw in is the PI lawyer gets paid a contingent fee on, among other things, the medical records. So in a follow the money sense, there's a reason for that diligence to generally be done. I don't know if 30 days makes sense.
Yeah, okay.
Certainly, I think the organization needs notice.
Okay, I'm hearing the 30 days may be a problem because this issue of the CCO is a little bit different than DHS. You caucused, what's your final answer?
well,
Well, I win that, because access wrongful death proceeds. The notice section, in ORS 416.530 does require notice, and that's, we're talking about that notice.
Yes.
CCO, but it says it's effectuated by noticing OHA or DHS.
Okay.
Not the CCO.
All right.
Also.
All right.
So DHS and OHA.
All right.
Will be the ones to know.
Okay, then we don't need to add the CCO. Good, thank you very much, done. Section 7. Oh, wait, Heather, you had a question about,
It's again a practical question that I don't think.
about which?
About E, subsection E.
Uh-huh.
In section 6.
Yeah,
So it's a practical question. We're supposed to give DHS and Oregon Health Authority any other information required by rule of the department or the authority. And the very practical problem that lawyers often have is finding where that is. Where any other information required by rule of the department or the authority is. Because they say, well, it's in the OARs, where, well, you know, where?
you Google Secretary of State.
Yeah, I get that, Lane, but when I regularly work with OARs that I'm quite familiar with, I have a
But,
tough
but
time.
wait a second, they have rulemaking authority,
yes, we do.
so all this says is be aware that there may be a rule. I mean, I don't think we can,
Their rulemaking authority derives from statute, so do you already
Well,
have this authority and there's no reason to include it?
Well, I think it's that if there are additional, if there's additional information that the agency implies from its authority here, that it may need some additional information,
So-
and they put that in rule.
where did E come from?
I don't know, I didn't put it there, but, and I didn't object to it for obvious reasons, but, so here's the thing. First of all, if somebody has questions about what's in our administrative rules, we have a phone number. Second of all,
That's even easier.
you know, this idea that, well, gee, I don't know where the rules are, well, gee, I don't know where the statutes are, or gee, I don't know where the Constitution is.
We struggled you know that we struggled when we had the whole, Oregon Health Authority and the, Oregon Department of Human Resources issues. The lawyers in private practice struggled to say,
Who's who?
yeah, who's who, and the department couldn't immediately reply because they didn't have that resolved. So for me to say, you know, we need to have, I'm not saying I'm complaining about giving you guys information, but as a practical matter, the reality is it can be hard to figure out, not everybody knows how to call, who to call. And we're talking.
But this isn't small estates, this is lawyers.
How much money are you getting paid per hour?
Well, and I mean, I just want to, I'm not sure that this is actually granting you rule authority. My sense is that you have pretty broad rule authority over
The federal
Medicaid,
law
over the
imposes a very
Medicaid.
broad,
Yeah.
responsibility, basically an unlimited responsibility on the Medicaid recipient to provide the information that's necessary for us to protect our lien interest.
Right.
And failure to do so is actually grounds for termination of the person's benefits.
Persons are dead, but.
I'm not
So-
arguing against it, I'm arguing about the practical problem that we face and how we solve that practical problem.
But I think this is also required in 113, because I'm looking at an old version of the statute, 113, 145, where requires information in errors and WDs to go to DHS and OHA. It says, or as otherwise provided by rule adopted by the authority.
There's where it came
That's
from?
where I-
Okay.
And I understand what you're saying, Heather, other places, other information.
But I understand what you're saying, but the reality is that everything in the state, every agency, you're subject to that agency for any reason, you're gonna have to find out where the rules are for anything. I mean, if you're a barber and a hairdresser and you wanna apply for a license, and you wanna be someone applying for a private career school, or you wanna, you know, whatever it is you wanna do, you've gotta find those where they are. And, you know, the DHS, maybe that's something that DHS can make sure they have on their pages, more information. If you have questions about rules, this is who you contact.
Well, I assume there's a rules link on the DHS page
You know,
anyway, but.
yes, but so that she's, you know, like, there's a lot of rules.
Yeah, I'm not troubled by
And
this.
they're piecemeal sometimes,
Yeah.
sometimes you find it here, and sometimes it's over here.
But I don't see this as a grant of rulemaking authority. I think they have the rulemaking authority. And
It probably would be a grant rulemaking authority, but you probably already have.
That's what I mean,
That's
yeah,
right. And
that's what I mean.
DHS probably can make whatever rules it wants to do.
Yeah. Yeah.
So let's take it out.
No, let's leave it
I'm not
in.
sure it's still in, I'm reconsidering about that being in 113, 145. Right, I think I was right.
Should I broaden it, maybe, than from what it was by tabulating this, but you're supposed to, the mail or deliver the information.
Well, what's the statute, 113?
145. I'm kind of over it.
Well, don't do that, because we changed it.
I know, that's why we keep giving that caveat.
113, 145
Is the mail?
relates to the address.
Right, that's the part that I read, it relates to the address. It doesn't give the agency the right to designate other information to be provided to the agency. And so why should that happen here when the purpose of this is to kind of overcome not giving notice under the regular probate statute? I agree with that.
Well, OHA does have a very broad rulemaking authority to comply with federal law, and I don't have the citation at my fingertips. And as I mentioned, federal law does require a very broad mandate as to what information, that basically the Medicaid recipient has to provide the information necessary, that we
Okay.
ask for.
Tell you what, would you let us know before the next meeting, do you have rulemaking authority that, by which you could require additional information, whether we say so in this bill or not? If you do, I think it's worth putting in as a signal that there may be other requirements, and we probably ought to put it in 113 too then.
I would say that if there's a list like this of the exact information you're supposed to provide, and then DHS goes and puts 10 other things on the list, we would probably reject that rule in our office.
Thank you.
All right, so let's work this out between the next meeting.
Yeah.
Okay.
Yeah. I'm not interested in creating new authority, but if they've got it, then I think it's fair to signal. So that's where I'm coming from. Okay, section 7. So, Gretchen, that's an assignment for you or Matt? Okay. And to work with Marissa, give her a pretend rule and see if she would approve it.
I have enough real rules.
Section, we are gonna finish this, folks. We are going to do it. Section 7, waiver requirements. When a PR is appointed, under Section 5, no other assets of the estate have been discovered. Okay, the following requirements are waived. Information to heirs, devotees, interested persons. Publication of proof of notice. Proof of compliance with diligent search for claimants. That is your garden variety probate claimants. And inventory.
So we need to add bond in there because we found out earlier.
Yeah. There's where we do it. That's right. Good. No bond.
And doesn't the court need a way of having verified that, in fact, this is a no asset probate? That's kind of what some of the courts do on the inventory. Is in that way they know, oh, wait, this is a.
Well, we've already said in the petition part that they have to state.
Yeah. Right.
Well, right, but what happens if it changes when they discover assets?
Well, then you have, this only applies if no other assets have been discovered. So if you have assets, then you're into the probate requirements. In lieu of filing this is B, in lieu of filing a final account, the PR may file a statement signed by the attorney representing the PR in a wrongful death claim, stating that damages accepted or recovered in a wrongful death claim have been distributed as provided in 030, and that incorporates reimbursement of expenses as well as apportionment. That's the waterfront. Oh, and this section does not limit or modify 0303. All right, how does that sound?
How do we fix, so no assets have been discovered, you commence because you think you have wrongful death, after reviewing medical records, you find out there's no wrongful death claim. So do we need to say anything in here? And, you know, if you don't end up having an effective claim, we know that you can, in lieu of filing a final account, say that the.
Oh, what if you just,
But what if you never recover?
Yeah, okay.
If you're a true no asset probate.
And then just add, or there were no, claims, there's no claim was recovered or whatever. Yeah, end of.
yeah, can you do that, Marissa? Or that no damages, because we're talking about here, let me see, damages accepted or recovered have been distributed, or that no damages, were received or something.
Yeah, but it's not just that. Sometimes we appoint a PR, for the, declaring the validity of the will.
Right.
Or a power of appointment.
Well, that's under our separate LC.
Okay,
Yeah, that's the no asset LC.
all right.
This one is no asset, but specific to, for wrongful death actions. Okay? Wow.
You know, the closing of the estate isn't in here. That must be in the other one.
In which one?
I was thinking of that because Jennifer had asked about, moving it.
Judgment closing.
Yeah.
No, we just suspend.
Oh,
Okay, so you're right.
I was remembering that from the other one.
Yeah, so we should incorporate the same kind of language about a judgment closing on the filing of that, statement under, B.
And then I had a question up here, did we talk about that? It was in, section 6, I'm not sure I understand this question anymore, but it says, does it make sense that this is only required when the only purpose is the wrongful death claim? What if there's a wrongful death claim plus other assets?
And that's a regular probate. Yeah.
Right, so in that case, you are not exempted
Right.
under the other statute.
Right.
I think that's fine.
Right.
Okay. Yeah,
You've got a wrongful death claim, yeah, you got basically a parallel process going on.
right.
All right, I'm gonna move on here, and you know, we'll look at this one more time, but I think we've made excellent progress in this. I'm really encouraged. Section 8, venue, for proceeding, seeking the appointment of a PR. D, in the county where a personal injury or wrongful death claim is defined, we're adding that as appropriate venue. We talked about that. Good with that? Section 9, property to subject jurisdiction of the court means all property owned by the decedent at the time of death that is subject to administration, including but not limited to amounts recovered on a personal injury cause of action. It would be personal injury claim, because that's a defined term, as defined in section 1.
Although I actually, it's not defined for this section.
No, it's not, yeah.
Oh, as defined in section 1, okay. Yeah, no, we're good.
Of this, oh yeah, the act, okay, yeah. Okay. So we're making clear there that wrongful, that PI damages are an asset of the estate. Was there a reason we wanted to clarify that? Just, some people didn't know?
Because
Yeah, I think that was it, some people didn't know.
Okay,
Do we like the phrasing though of amounts recovered? In some reasons I do, and in some reasons I don't. Isn't the claim, I mean, at the,
this is, oh, okay, wait a second, is this the attorney fee statute? Yeah,
it's the PR.
right.
oh, is that,
Yep, that's what it is. That's right. That's what it is. So that recovered is the correct word there.
PR?
Yeah, this is the PR. Yeah, Brooks.
Sorry to interrupt. I got to go to a meeting like Bonnie did. So as always, thank you for letting me participate, and hopefully I'll be there next time in person.
Yeah, okay, thanks. Been very helpful.
Bye, everybody.
Okay. Okay, so that's right. We were just incorporating damages as being in consideration of the,
Yes, I do like amounts recovered.
yeah. And same thing under E, it's recovered claim for wrongful death.
So could we just call it wrongful death claim, because that's the defined term?
Yeah, I think that's probably right. So we do personal injury claim in A and wrongful death claim in E. And we are done. Hey, wow. Okay, so next week, not next week, next meeting.
So here's the thing, and I want to make sure everyone, we don't have another meeting scheduled for November 29th. The reason for that was that it was difficult with Thanksgiving coming up to find a time in the middle of November that all the essential parties could meet.
Yep.
If there are any topics that a small group would like to discuss, I am happy to help arrange a meeting. Just let me know and we can do that.
And let's plan on that. We can maybe meet in the conference room.
Yep.
And by small group, that means anybody who wants to be there.
Yes.
We are deep into 111, and we've been having
Yay!
a meeting of lawyers who are highly familiar and
If you want to bring what you've got for your work.
We're about to hit the meat of 111. We've got almost everything done except for struggling with the issues of the ORC and.
Yeah.
So just let me know.
Okay, my sense is I'll want to have an interim meeting sometime in November, just to keep this thing moving and maybe not look at the wrongful death. I think we'll wait until we have a full group with our wrongful death people back, the grateful wrongful death.
What I may do, I'll pass it over.
Better to know now than to hear them, you know, when we're going
Oh, no, oh, I do too. No, this is exactly what I wanted. And it's been very helpful for us, I think, to avoid some pitfalls if we'd gone down the path of the pristine, Constitution or something. Matt, you had something.
Yeah, actually, before we get off of that PRP statute, so we're adding in there that the PRP is going to be calculated based on amounts recovered for a personal injury claim or wrongful death claim. Remember in paragraph 2, we have language about how those assets are to be valued at the highest values of various documents.
Of course, we're changing that language a little bit here.
I think maybe for, next time, I think we want to make sure that how we're valuing it, is still only going to reflect that for those claims, it's the amount you're recovering. So when you.
Well, that's what it says though, amounts recovered.
I know.
Yeah, so I think that narrows.
Think of that. Will we look at this again
Okay.
at some point?
Yeah, and we are looking at it in connection with the other change that we got from
Yeah.
Steve.
We just discussed last.
Yeah, so, okay, so, but that's a good point.
I don't want to have a
The
PR.
$10 million.
Yeah, right, but of course it does say recovered, do we need to refer back up to?
You can say receipt.
Well, but I mean, in 2, we say highest value, do we need to kind of remind everybody that just above that, we talked about recovered for PI and wrongful death claims as opposed to the amount of the prayer?
You can say each asset except for personal injury.
Right, yeah, that's what I'm saying, just in 2, we addressed that. Okay, so Sandy will
Yeah,
circulate a date for, and I think what I'd like to do at that one is probably look at the no asset draft, that's kind of bite-sized, and if we have time, do some more work on the, and maybe review the statutory, the form.
So what I'm gonna do is, I'll work with Lane to find a date. I'm gonna send out another scheduling link for the week before Thanksgiving,
Okay.
and maybe even early that week,
Yes,
to see how
yes.
many people we can get there.
Sure.
And I'll schedule a meeting either for this room or across the street.
So the bottom line is, the small group means everybody who can
Wants
and
to be
feels
there.
like coming.
Yeah. All right.
All right, people on